Hi, Derek Fahey, patent and trademark attorney with the Plus IP firm. This video is going to be on strategies that you can use to get broader patents and potentially broader patents faster. Okay, so let's start off. First off, when you file a patent application with the United States Patent and Trademark Office, it's examined by a patent attorney at that office. And they do their own search and they may find different references that could affect your ability to get a patent on the invention. Eventually, you may go back and forth with the patent office and the examining attorney when they examine the claims section. And generally, the claims section is at the last or the shortest part of the patent, and it's the most important part of the patent. And the examining attorney, they may reject some claims, they may actually allow some claims. In the office action that you get, you may see towards the end of the actual office action, you may actually see something that says that the claims are in a condition for allowance. Okay, that is a great thing. When you get that, that means the examining attorney thinks that those particular claims are allowable, and that's good. Why is that good? That means that how you may be able to get some intellectual property here. That's fantastic, which is great news. Now, when you get that, you have to think about how can you actually what you should do next, right? Do you want to take those allowable claims or do you want to fight for more? Sometimes the strategy can be, well, you know what? I want to keep on fighting for the broader set of claims. You may say, okay, examiner, I find that I'm glad you think these are allowable, but I think I'm actually entitled to more protection. And you actually have to respond to the office action to try to fight to get more protection. One strategy you can do is you can actually respond, take the allowable claims, get patent, and then you can actually file what's called a continuation in part patent application. The continuation in part patent application is an application that's pending with the application already filed. So you must file that continuation in part or continuation application or divisional patent application before you actually get the granted patent. So one strategy is to take what the examiner gives you and then go after the broader set of claims in another application known as a continuation in part, a continuation, or a divisional patent application. That is one strategy. You may want to employ that strategy if you need to get a patent, whether it's sometimes people are you're trying to raise capital and you want to say you have a patent. That's one reason why you want to use, I call it the planting the flag strategy. You plant the flag on this particular intellectual property, and then you file another application that's pending with this application called a continuation in part, or divisional application, and try to fight for that broader protection. Okay. Again, one strategy for doing that is if you need a patent to try to raise capital. Another reason why you want to employ that strategy is because sometimes if the examining attorney actually goes back, if you respond, they may find additional prior art and they may actually no longer find some of those claims allowable, which happens. So you may want to take what they give you, get that patent granted, and then fight for some other protection. Another strategy you can employ is respond and fight for the broadest set of claims. In that particular strategy, you may have already employed that first strategy of filing an application and planting your flag. Now you really want to push and fight for the claims you can get. So that in that particular case, you may want to file multiple responses and really fight and push the limits of what the boundaries that you can get for the claims. You want to fight and try to get the broadest protection possible. In those particular cases, as I mentioned, you may already have an existing patent, and now you're just trying to further flesh out the intellectual property. Another reason why you may want to file or try to push the envelope is it's a very competitive marketplace, and you want to try to lock out as much competition as possible. You know that how the competition is very competitive, and that you want to try to have the broadest protection as possible, and you want to go enforce that broader patent against other entities or other individuals, because you know that how your patent is broad enough that you can actually stop other people from entering the space. So those are two different types of strategies you can potentially employ. One, if an examiner gives you allowable subject matter, get those claims allowed, and then file another application as a continuation part, and a continuation application to potentially broaden the scope of intellectual property. And the second way to do that is to basically, second strategy would be to actually try to go for the broadest protection possible that you can get in that particular application, and fight for as long as you can to try to get the broadest protection possible. So, two different strategies. Hope you found that this video was useful. Have a great afternoon or evening wherever you are. You can find me online, www.plusfirm.com. Please like and subscribe to this channel. Thank you so much for watching. Again, my name is Derek Fahey. You can find me on Instagram, Derek Fahey, PA, DEREK, FAHEYPA, and also on TikTok. See ya. Thanks for watching.